net degree. So today we will be discussing some MCQs which are relevant for the upcoming exams. We will try to cover the topics along with the MCQs as comprehensively as possible. So let's begin. The first question is the ground for decree for dissolution of marriage under section 2 of the Dissolution of Muslim Marriage Act 1932 are that the whereabouts of the husband have not been known for a period of 2 years. Let's see the options first, then we will answer. Husband has been sentenced to imprisonment for a period of 5 years. Okay. Husband has failed to perform without reasonable cause his marital obligations for a period of 2 years. And husband has neglected or failed to provide for maintenance of his wife for a period of 1 year. So here the answer would be D. None of these. So why these options are incorrect, I will elaborate in a few lines. So there are totally 7 grounds of dissolution of marriage. Seven grounds of dissolution of marriage. That is, first is whereabouts of the husband have not been known for a period of 7 years. Husband has been sentenced to imprisonment for a period of, so imprisonment is for 7 years. Husband has neglected or failed to provide for maintenance of his wife for a period of 2 years. So, and apart from these grounds, other grounds are impotency, insanity, leprosy, cruelty, etc. So, let's move to second question. Yes. According to Bharatiya Nyaya Sanhita, what is the maximum punishment for committing the offence of bribery under section 173? So, let's first look to section 173 of BNS. It says section 173 of BNS punishes bribery in connection with elections, and it shall be punished for a description for a term which may extend to 1 year. One year or with fine. So here the correct answer would be answer option B, imprisonment for up to 1 year or fine or both. Next question is, by constitution amendment applicable to Jammu and Kashmir Order 2019, which articles are amended? So here the answer would be Article 367 and 370. Article 367 and 370. Article 367 was amended and subclause 4 was added into it. Subclause 4 added into it, and it states that Constitution will apply to whole constitution will apply to entire state of Jammu and Kashmir. So, firstly, this article 367 subclause 4 was added, and after that 370 was repealed, which granted special autonomous status to Jammu and Kashmir. So, the answer would be option A. Question number 4. According to Bharatiya Nyaya Sanhita, what is the maximum fine for making or using a document that resembles a currency note or bank note under section 182 subclause 1? So, if we see section 182 of Bharatiya Nyaya Sanhita, it clearly states that whoever makes or uses for any purpose whatsoever any document purporting to be or in any way resembling or so nearly resembling as to be calculated to deceive any currency note or bank note shall be punished with fine which may extend to 300 rupees. मतलब अगर किसी ने भी कोई भी ऐसा डॉक्यूमेंट बनाया जो या तो सिमिलर है और इतना सिमिलर है कि वो लोग पहचानने में गलती कर सकते हैं, लोगों को वो डिसीव कर सकता है, तो उस केस में फाइन है, आप फाइन इन्होंने सेट किया है 300 रुपीज ओनली. So next question is, after a government notification is issued for acquiring Mr. Mehta's farmland under the Land Acquisition Act 1894, he notices that the income from his crop steadily decreases until the authorities finally take possession. What type of loss is compensable? So, यहाँ पे जो सेक्शन 24 ऑफ लैंड एक्विजिशन एक्ट है, सेक्शन 24 ऑफ लैंड एक्विजिशन एक्ट ये अब रिपील हो चुका है. ये लैंड एक्विजिशन एक्ट ऑफ 1894 में हुआ करता था, जो अब ये रिपील हो चुका है. लैंड एक्विजिशन एक्ट ऑफ 2013 में ये रिपील हो चुका है, बट इसमें भी इन्होंने सिर्फ और सिर्फ बोनाफाइड डिमिन्यूशन ऑफ प्रॉफिट्स ड्यू टू एक्विजिशन प्रोसेस, सिर्फ इसको ही कंपनसेट करने की बात कही थी. बाकी ये तीनों लॉसेस जो है ये कवर नहीं होते थे, इनके लिए कोई भी कंपनसेशन नहीं मिलता था. तो ये कंपनसेशन बोनाफाइड डिमिन्यूशन ऑफ प्रॉफिट्स ड्यू टू एक्विजिशन प्रोसेस फ्रॉम नोटिफिकेशन, फ्रॉम द डेट ऑफ नोटिफिकेशन, जिस दिन नोटिफिकेशन एक्विजिशन की नोटिफिकेशन हुई अंडर सेक्शन 4 एंड टिल द डेट ऑफ पोजेशन, टिल पोजेशन अंडर सेक्शन 16, इस बीच में जो भी प्रॉफिट्स का लॉस हुआ है इसको बस हम कंपनसेट करते थे, जो कि 1984 ऑफ लैंड एक्विजिशन एक्ट में कवर होता था. अब वो रिपील हो चुका है. Now next question is, section 152 of Bharatiya Nyaya Sanhita replaces which controversial law? सेक्शन 152 ऑफ भारतीय न्याय संहिता सबसे पहले अब आता है, ये आईपीसी में होता था 124A ऑफ आईपीसी, एंड इट कवर्ड सेडिशन लॉ. व्हाट इज सेडिशन? लेट अस फर्स्ट अंडरस्टैंड व्हाट इज सेडिशन. सेडिशन एक ऐसा एक्ट है जो इंडेंजर करता है सोवरेनिटी, यूनिटी एंड इंटीग्रिटी ऑफ इंडिया. कोई भी इंसान, एनी पर्सन purposefully by words, sign, or electronic communication. Excites, secession, armed rebellion, or subversive activities. Activities. So किसी भी इंसान के ऐसी एक्टिविटीज बाय वर्ड, साइन, इलेक्ट्रॉनिक कम्युनिकेशन, किसी भी तरीके से वो कुछ ऐसी एक्टिविटीज करता है जिसकी वजह से सेसेशन, आर्म रेबेलियन या कोई भी ऐसी सबवर्सिव एक्टिविटीज होती है जिससे देश में इस तरह की चीजें, इस चीजों का खतरा, मतलब सेसेशन, आर्म रेबेलियन, सबवर्सिव एक्टिविटीज का खतरा होता है, तो उसको हम सेडिशन के अंडर कवर करते हैं और इसका पनिशमेंट है 7 years imprisonment and fine. It was earlier under 124A of IPC and now it is covered under section 152 of BNS. Let's move towards next question. Which section defines rape under Bharatiya Nyaya Samhita? So earlier in IPC, rape was defined under 375 of 375. Now it is replaced by section 61. 63. 61 is about criminal conspiracy. Section 69 is about sexual intercourse by deceitful means. And section 70 is gang rape. Now question number 8. Question 8. Match list 1 with list 2 and state the correct answer using codes given below. Legitimacy of children of void and voidable marriage. Punishment of bigamy, judicial separation and voidable marriage. So यहाँ सबको पता होगा judicial separation is section 10. So 3 का 1, voidable marriage is 12, section 12, that is 2. Punishment for bigamy is 17, that is section 17, option number 3. And legitimacy of children of void and violable marriage, it is section 16, that is option 4. So the correct answer is C. Next question. Next question. During investigation, a search can be conducted without warrant by. For solving this question, we need to go through 165 of CRPC or 185 of BNSS. 165 of CRPC and 185 of BNSS. It says it empowers a police officer in charge of a police station or making an investigation to conduct a search without warrant after recording in writing his grounds of belief and specific things to be searched for. So it can be conducted by any police officer given he records in writing his ground of belief and specific things to be searched for. Then only he can conduct a search without warrant. Question number 10. Which section of CRPC deals with irregularities which vitiate proceedings? So, for solving this question, we need to understand section 461 of CRPC and at the same time now 404 of BNSS. It categorizes 17 categories of irregularities which are committed by magistrate. So, if these 17 categories of irregularities are committed by a magistrate, then the entire trial or proceedings would be declared null and void. And these sections 460 of CRPC deals with irregularities that do not vitiate the proceedings. 462, it is about place of inquiry. Section 468 deals with limitation. So here the correct answer is option number B, section 461. Next question. Which statement is true about organized crime under section 111 of the BNS 2023? Any continuing unlawful activity including kidnapping, robbery, vehicle theft, extortion, contract killing, economic offences, cybercrime, trafficking of persons, drugs, weapons, etc. includes property of any description except land and things attached to the earth, etc. This option is correct. This option is right. Organized crime syndicate means a group of two or more persons acting either singly or jointly as a syndicate or gang indulging in continuing unlawful activity. This is also correct. Continuing unlawful activity. Unlawful activity means an activity prohibited by law which is a cognizable offence punishable with imprisonment of 3 years or more undertaken by any person either singly or jointly. All of the above options are correct. Yes. Yeah. Yeah. Question number 12. According to Indian Contract Act, when is the communication of an acceptance complete against the proposer? So, for this, we need to know section 4 of Indian Contract Act, which says the communication of an acceptance is complete as against the proposal when it is when it is put in course of transmission to him so as to be put out of the power of acceptor, so as to put beyond the control of the acceptor. So here option B is correct. Same is for same will be applied when the question is asked as against the acceptor. Next question 13. Under which of the following sections of CRPC relating to police report is given? So section uh, let's go through the options first. Section 177 is about police to inquire and report on suicide matters. Suicide by a woman 7 years of within 7 years of marriage. Section 174 subclause 2 subclause 1 is sorry. Section 174 subclause 2 subclause 1 is about police to inquire and report on suicide by a woman within 7 years of marriage. Section 177 is about place of inquiry. Section 175 is about power to summon persons. And section 173 subclause 2 subclause 1 is about police report upon completion of investigation. So answer option number A is correct here. Question 14. Under section 320 subclause 1 CRPC for criminal intimidation, which section of IPC is applicable? So we first need to know what is 320 subclause 1 of CRPC. It is about compounding of offences. And इस क्वेश्चन को सॉल्व करने के लिए पहले हमें इन सेक्शंस में है क्या वो जानना पड़ेगा. तो 503 डिफाइन करता है क्रिमिनल इंटिमिडेशन. 504 intentional insult, invoking breach of peace. 505 है statement conducing to public mischief. And 506 है punishment for criminal intimidation. So ऑप्शन नंबर डी इज करेक्ट हियर. क्वेश्चन ये पूछा जा रहा है कि सेक्शन 320 सब क्लॉज 1 ऑफ सीआरपीसी के अंडर किन ऑफेंसेस को कंपाउंड कराया जा सकता है. इट इज सेक्शन ऑप्शन नंबर डी, दैट इज 506, पनिशमेंट फॉर क्रिमिनल इंटिमिडेशन. In which of the following question a statement is followed by two conclusions, one and two statements. Under the Protection of Women from Domestic Violence Act, a magistrate may issue a protection order. Conclusion 1 is a protection order can cover not just financial and not just physical violence but also financial and emotional aspects of domestic violence. The magistrate has wide powers to restrict the respondent's conduct to safeguard the aggrieved person and her dependents. Here, both the options are correct. Protection order is given in section 18 of DV Act. So here both the options are correct. 16. Which of the following is true of summons under section 61 of CRPC? Section 61 of CRPC is now 63 of BNSS. तो इसमें हमें 63 ऑफ BNSS के अंदर फॉर्मल रिक्वायरमेंट्स दिए हैं एक लीगल समन के. Formal requirements of a legal summon. First, it should be given in written format. Second, duplicate copies must be prepared. Third is authorized signature by PO of court, presiding officer of court. And fourth is official seal of the court. ये 4 इंग्रेडिएंट्स होंगे तभी एक लीगल समन माना जाएगा. सो नाउ अब हम ऑप्शंस देखते हैं. अगर इट इज माइल्डर फॉर्म ऑफ प्रोसेस, यस ट्रू. इट इज फॉर अपीयरेंस, यस. इट इज फॉर प्रोड्यूसिंग डॉक्यूमेंट्स और थिंग्स, all of them are correct. Question 17. When did Bharatiya Nyaya Sanhita Bill 2023 receive the assent of President of India? Yes. So ये तो बहुत स्ट्रेट फॉरवर्ड क्वेश्चन है, बट 2-3 थिंग्स वी नीड टू नो. इट वाज पास्ड इन लोकसभा on 20 December 2023, in Rajya Sabha 21st December 2023, presidential assent on 25th December 2023 and came into force on 1st July 2024. So along with Bharatiya Nyaya Sanhita, IPC was replaced by BNS, Bharatiya Nyaya Sanhita, CRPC was replaced by BNSS, and Indian Evidence Act was replaced by BSA. Question number 18. Rahul rents a shop for retail business. Landlord wants to terminate the lease. What notice period is required under Transfer of Property Act 1882? So for this we need to understand section 106 of Transfer of Property Act. Section 106 of TPA, Transfer of Property Act, says if lease is for agricultural or manufacturing purposes, so it will be renewed from year to year basis, terminable year to year basis, and terminable by 6 months notice. And for other purposes, lease from month to month basis, and terminated by 15 days notice. Here, Rahul is renting a shop for retail business, which does not come under agriculture or manufacturing purposes. So, it falls under the second category, that is terminated by 15 days of notice. So, answer B is correct here. Under section 239 CRPC, the magistrate can, so first we need to understand section 239 of CRPC. 239 of CRPC is about discharge the accused if charges are groundless. So, if in warrant cases, if upon considering report, and after giving prosecution an opportunity of being heard. If after giving prosecution an opportunity of being heard and magistrate feels that the charges are groundless, then he can discharge the accused under section 239 of CRPC. Here answer B is correct. Next question is, police can seek a bond for good behavior under section 109 and 110 CRPC from. So 109 is about security for good behavior from suspected person. And 1010 is about security of good behavior from habitual offenders. So here answer A is correct, habitual offenders. Question 21. In which of the following of the section 59 CRPC the discharge of arrested person by a police officer can take place? So section 59 of CRPC, says no person who has been arrested by a police officer shall be discharged except on his own bond, on bail, or under special order of magistrate. So तीनों कवर हो रहा है इसके अंदर, सो आंसर डी इज करेक्ट, ऑल ऑफ देम. Question 22. If a case is transmitted to the central government under Section 10 of the Special Marriage Act 1954, what is the time limit for solemnizing the marriage after its decision? So, under Section 10 of Special Marriage Act, if where an objection to the intended marriage has been transmitted to the central government, objection to the intended marriage has been transmitted to the central government, and it has been decided in favor of the parties, then the marriage must be solemnized within 3 months of that order. So answer D is correct here. According to section 137, what constitutes kidnapping from India under Bharatiya Nyay Sanhita? Section 137 of BNS. Section 137 of BNS says whoever conveys any person beyond limits conveys any person beyond the limits of India without consent. This is the clear answer here. Without consent of that person or some person legally authorized to consent on his behalf if the person is minor. So, question number 24. In order for that, in order that a decision in a formal suit may operate as res judicata, the court which decided that suit must have been a civil court of competent jurisdiction, right? A court of exclusive jurisdiction? No. A court of concurrent jurisdiction competent to try subsequent suit? Correct. A court of limited jurisdiction competent to try the issue raised in the subsequent suit? No. So either one or three. Correct answer is option number A. Question number 25. An order under Order 33 Rule 11 directing the pauper plaintiff to pay the court fee can only be made in which cases? So, Order 33 Rule 11 Order 33 Rule 11 permits an order for payment of court fee by an indigent person where the plaintiff is dispaupered under Rule 9 and where the suit is dismissed under Rule 5A or B. So, here the answer is 2 and 4. 2 and 4. 23. 26. Which of the punishment is not provided under Bharatiya Nyay Sanhita 2023? Not provided. So, at first we need to know section 4 of BNS provides for six types of punishment. First is death. Second is imprisonment for life. Third is imprisonment, rigorous or simple. Fourth is fine, and sixth is community service. This was recently added in BNS. So here, which of the following is not provided under BNS? All of these are provided under BNS, so answer D would be correct. Question number 27. What is the maximum term of imprisonment prescribed under section 31 of section 31 of Protection of Women from Domestic Violence Act for breach of protection order? So question number 27. Yes. Section 31 of Protection of Women from Domestic Violence Act says a breach of protection order of an interim protection order shall be punishable with imprisonment which shall extend up to 1 year, or fine which may extend up to 20,000. So answer B is correct. 28. Which of the statement is correct, true about terrorist act under section 113 of BNS? And any act that threatens or is likely to threaten India's unity, integrity, sovereignty, security, or economic security. Correct? It also includes acts that strike or are likely to strike terror in people in India or in foreign countries, right? For the offence of terrorist act, officer not below the rank of superintendent of police shall decide whether to register the case under this section or under the Unlawful Activities Prevention Act 1967. Correct. So all these three options complete the definition of terrorist act under section 113 of Bharatiya Nyaya Samhita. Now question number 29. Given below are two statements, one labeled as assertion A and the other labeled as reason R. Assertion A. Under the Hindu Succession Act 1956, a daughter in a joint Hindu family governed by Mitakshara law becomes a co-partner by birth in her own right, just like a son. Right? ये तो सही है. Reason given for this is the provision grants daughter the same rights, liabilities, and disabilities in co-partnership properties as those of sons. So both assertion and reason are true, and R is the correct explanation of A. To give a brief background, here in Vinita Sharma versus Rakesh Sharma, it says that daughters hold co-partnership right retrospectively regardless of the fact whether father was alive in 2009 or not. 2009 में फादर जिंदा थे या नहीं थे इससे कुछ भी फर्क नहीं पड़ता है. ये एक्ट जो 2005 में जो डॉटर्स को को-पार्शनरी राइट्स मिले हैं ये रेट्रोस्पेक्टिवली वर्क करेंगे. नाउ क्वेश्चन नंबर 30. A choose B for a declaration of title to land and obtains a decree. A then choose C for possession. C contends that B is the owner and that he is in possession as B's consent, B's tenant. So this is a case of constructive res judicata. कंस्ट्रक्टिव रेस जुडिकाटा का केस है ये। यहाँ एक बार ए ने बी के अगेंस्ट एक डिक्री ले ली है अपने फेवर में, डिक्री ऑफ डिक्लेरेशन। Decree of declaration is decided in favor of A and against B, and now C is claiming the tenancy rights from B. तो यहाँ पे C is bound by prior judgment. Prior judgment in which A has got the decree of declaration. तो यहाँ B के पास कुछ है ही नहीं, इसलिए C इस B के थ्रू टेनेंसी राइट्स क्लेम नहीं कर सकता है। दिस इज अ केस ऑफ कंस्ट्रक्टिव रेस जुडिकाटा। क्वेश्चन नंबर 31. A sues B to recover one of the two properties left by C on the ground that he and not B is his heir. Thereafter, he applies to amend his claim for including the second property left out in the plaint as originally filed. B opposes the application for amendment, which is disallowed by the court. A suit by A against B to recover the second property as heir of C would be barred under Rule 2. So, why it would be barred? Because A is to be taken to have omitted to sue for it in the first suit. He made an attempt to include it in that suit, which was foiled by the opposition of B. It is clearly written in order to Rule 2. So, here the answer would be both A and B. According to Bharatiya Nyaya Sanhita, what is the intent required for crime described in section 143, 140 subclause 3? Section 140 subclause 3. It was in IPC as section 365. 140 deals with aggravated kidnapping. Aggravated kidnapping or abduction. And subclause 3 of 40 specifically punishes kidnapping or abduction with an intent to cause that person secretly and wrongfully confined. Wrongfully confined. तो यहाँ आंसर होगा ऑप्शन नंबर सी, टू कॉज wrongful confinement. 140 subclause 3. Question number 33. According to Negotiable Instruments Act 1881, what is the maximum sentence of imprisonment a magistrate may pass in summary trial under section 143? So here in section 143 of Negotiable Instrument Act, if we see the bare act, it is clearly written that it follows 1 year of imprisonment and fine not exceeding 5,000, fine exceeding 5,000 rupees. Fine 5,000 rupees. So here answer would be C. Answer would be C. 1 year's imprisonment. Question number 34. Which is not correct, which are not correctly matched regarding Bharatiya Nyay Sanhita 2023. Here, extortion 302 wrong, criminal breach of trust 314 wrong, receiving of stolen property 315 it is also wrong, defamation 356 it is correct. So here the correct answer is D. Correct answer is D, but extortion is under 308, criminal breach of trust is under 316, receiving of stolen property is under 317. So correct answer here is option number D, defamation 356 of IPC, BNS, sorry. The UN Central Model Law and rules do not become part of Arbitration Act so as to become an aid to construe the provision of the Act failed in the case of यहाँ पे इसका आंसर है यूनियन ऑफ इंडिया वर्सेस ईस्ट कोस्ट बोट बिल्डर्स एंड इंजीनियर्स लिमिटेड। इसमें ये कहा गया था कि इफ इट ओनली ड्रॉज, मतलब ये जो हमारा आर्बिट्रेशन एक्ट है, आर्बिट्रेशन एक्ट ओनली ड्रॉज इंस्पिरेशन फ्रॉम यूएन सेंट्रल मॉडल, from UN Central Model and not incorporated into formal statute. इसलिए it does not become an aid to construe the provisions of Arbitration Act. UN Central Model just एक इंस्पिरेशन उससे लिया गया है जो हमने आर्बिट्रेशन एक्ट में फॉलो किया है, इसको हम फुल्ली इनकॉर्पोरेट नहीं कर पाए अपने एक्ट के अंदर। नेक्स्ट क्वेश्चन इज क्वेश्चन नंबर 36. For a petition for nullity of marriage under Hindu Marriage Act on the ground of fraudulent consent, what is the statutory bar to granting the decree? Sorry. So, on the ground of consent was obtained by fraud, what is the statutory bar to granting the decree? So here the answer would be petitioner has lived with the respondent as husband and wife after the discovery of the fraud. फ्रॉड की डिस्कवरी होने के बाद भी petitioner जो है respondent के साथ husband and wife की तरह रह रहे थे, तो ये एक statutory bar है। और इसके बाद आपको मतलब स्टैट्यूटरी बार टू ग्रांटिंग ऑफ डिग्री ऑफ डाइवोर्स आपको नहीं मिल सकता है, ये बार की तरह काम करेगा अगर फ्रॉडुलेंट कंसेंट के बाद भी दोनों साथ में रह रहे हैं तो। ऑप्शन नंबर बी इज द करेक्ट आंसर। क्वेश्चन नंबर 37. क्वेश्चन नंबर 37. According to Section 7, Subclause 4 of Arbitration and Conciliation Act, an arbitration agreement is in writing if it is contained in a document signed by the parties, an exchange of letters, telex, telegram, or other means of telecommunication which provide a record of the agreement, An exchange of statement of claim and defense in which the existence of the agreement is alleged by one party and not denied by the other. All of them are correct. If we see the Bare Act, all of these are covered under section 7 of 7 subclause 4 of Arbitration and Conciliation Act. Question number 38. Waiver of right to object deviance from arbitration agreement is mentioned under which section of Arbitration and Conciliation Act? So, very simple question. Directly from Bare Act, it is under section 4 of the Arbitration and Conciliation Act. Question number 39. The Arbitration Act 1996 repeals the Arbitration Act 1940, Arbitration Act Arbitration Protocol and Convention Act 1937, Foreign Awards Recognition and Information Act Enforcement Act 1961. All of them are correct. Arbitration Act repeals all these three acts. Now question number 40. In the following question, a statement is followed by two conclusions. As per section 157 of Companies Act 2013, every company must, within 15 days of receiving intimation under section 156, furnish the director identification number of all its directors to the registrar with prescribed fees. Failure to comply attracts penalties. ठीक है, ये हमारा स्टेटमेंट है. This is the statement and conclusion में है, if a company fails to furnish the DIN, it can be penalized, and every officer of the company in default is also liable for penalties. Both conclusion 1 and 2 are correct. Both conclusion 1 and 2 follow. Question number 41. Requisites of a valid adoption. Requisites of a valid adoption is given in no adoption shall be valid unless the person adopting has the capacity and also the right to take in adoption. ठीक है, the person giving in adoption has the capacity to do so, and the person adopted is capable of being taken in adoption, and adoption is made in compliance with the other conditions mentioned in this chapter. So this covers the entire requisites of valid adoption. Section 8 is about here, section 6 is about the requisites of valid adoption. So here answer A would be correct, but section 8 of the HAMA is about legal capacity of female Hindu to adopt. Section 12 is about legal effects of adoption. लीगल इफेक्ट्स ऑफ अडॉप्शन के अंडर आता है इंटीग्रेशन, कंप्लीट इंटीग्रेशन. कंप्लीट इंटीग्रेशन का मतलब है कंप्लीट इंटीग्रेशन, the adopted child becomes the part of adopting family. And second is severance of previous ties. जिस भी फैमिली से उसका अडॉप्शन, जिस भी फैमिली ने अडॉप्ट किया है उससे उसके टाइज जुड़ जाएंगे और पुरानी फैमिली से उसके सारे टाइज ब्रेकअप हो जाएंगे. सेवियरेंस ऑफ प्रीवियस टाइज. And section 10 is about eligibility criteria for a person who can be validly adopted. So here answer A is correct. For reference, section 8, 12 and 10 is also discussed. Section question number 41. 42. According to Muslim Women Protection of Rights on Marriage Act 2019, any pronouncement of talaq as defined under the act by a Muslim husband upon his wife by words either spoken or written or in electronic form or in any other manner whatsoever shall be, it shall be void. It is given under section 3 of Muslim Women Protection of Rights, मुस्लिम वुमेन प्रोटेक्शन ऑफ राइट्स ऑन मैरिज एक्ट सेक्शन 3 के अंदर दिया हुआ है कि इस तरह के जितने भी तलाक हैं वो वॉइड माने जाएंगे. सेक्शन 40 क्वेश्चन नंबर 43. As per the Hindu Marriage Act 1955, two persons are said to be within the degree of prohibited relationship if one is lineal. At first, two persons are said to be within the degree of prohibited relationship. This is given under section 3 subclause G of Hindu Marriage Act. Degrees of prohibited relationships is defined under section 3 subclause G of Hindu Marriage Act, and here one is lineal ascendant of the other, including relationship by adoption. True. One was the wife or husband of a lineal ascendant or descendant of the other, including relationship by half or uterine blood as well as by full blood. Correct. One was the wife of the brother or the father's mother's brother or of the grandfather's or grandmother's brother of the other. Correct. The two are brother and sister, uncle and niece, aunt and nephew, or children of brother and sister of two brothers or of two sisters. All of these are correct. So option B is right. Question number 44. Hindu Succession Amendment Act 2005 provides for women co-partnership rights at par with men, right? Inheritance right in agricultural land from her parents at par with her brothers, correct? Inheritance of self-acquired agricultural land of her deceased husband. Yes. Section 6 of Hindu Succession and Amendment Act. Succession Amendment Act HSAA 2005. इसके अंदर ये सारे राइट्स वुमेन को मिलते हैं. क्वेश्चन नंबर 44 45. Section 25 of Hindu Marriage Act provides for Section 25 of Hindu Marriage Act provides for permanent alimony and maintenance to wife. Permanent alimony and maintenance to wife. Section custody of children is under section 26. Maintenance pendant light is under section 24, and division of matrimonial property is not provided in Hindu Marriage Act. Question number 46 now. In the following question, a statement is followed by two conclusions 1 and 2. Statement: according to the Child and Adolescent Labor Prohibition and Regulation Act 1986, the appropriate government credits 15,000 to the child and adolescent labor rehabilitation fund for each child or adolescent for whom the fine amount from employer has been deposited. The amount in the fund is deposited or invested in banks, and interest accrued is also payable to the child or adolescent. Conclusion: the child or adolescent is entitled not only to the credited amount but also to the interest accrued on it, right? The government is not required to deposit any money other than what is collected as fine from the employer. So here only conclusion 1 will be right. Only conclusion 1 will be, only conclusion 1 is right. So next question. A Hindu wife had been living with her children, and all the children had been brought up by her without any assistance and help from the husband many years. The wife was entitled to separate residence and maintenance under which section? So here under section 18(2)(a) of the Hindu Adoption and Maintenance Act, the wife was entitled to separate residence and maintenance. Separate residence and maintenance under section 18 subclause 2A of the Hindu Adoption and Maintenance Act. And other sections here, section 2F, इसके अंदर है, if the husband has ceased to be a Hindu, 2 का D है, any other wife living, 2 का G है, there is any other cause justifying for separate living. Justifying living separately. So here answer C, option number C is correct. Question 48. On and from the commencement of Hindu Succession Amendment Act 2005, in a joint Hindu family governed by Mitakshara law, conferring on daughter co-partnership status by substituting new section for section 6. Section 6. We have discussed it earlier. So next question is section 14. Question 49. Section 5 of Hindu Marriage Act relates to here conditions of Section 5 of Hindu Marriage Act relates to conditions of Hindu marriage. Conditions of Hindu marriage. Void marriages are covered under Section 11. Voidable marriages are covered under Section 12. And ceremonies of Hindu marriage are covered under Section 7. Next question is 50. As per the Information Technology Act, intermediary with respect to any particular electronic record means any person who on behalf of other person receives, stores or transmits that record or provides any service with respect to that record and includes, who all are included under the definition of intermediary. So here telephone service providers, yes. Search engines, yes. Cyber cafes, yes. Online auction sites, yes. So option D is correct. 1, 2, 3 and 4. And this definition is given under section 2 subclause 1 subclause W of IT Act 2000. Next question. Question number 51. A marriage between a girl of 22 years marries her maternal uncle's son. Maternal uncle's son of 23 years in accordance with Special Marriage Act. Such marriages is, so it is valid because section 4 of Special Marriage Act read with Schedule 1 does not include first cousins. यहाँ गर्ल और उसके maternal uncle son के बीच में first cousin का relation है, which is not covered under section 4 of Special Marriage Act, so the marriage will be valid. Answer is option A. Question number 52. The utility of public interest litigation. The utility of public interest litigation is liberalized locus standi. Yes, sahi. The proceedings are non-adversarial. Wrong. Procedural requirements are liberalized. Here the answer would be liberalized locus standi. So, what is PIL? It allows any public, it allows any public stringent citizen to approach the court on behalf of those who cannot approach the court directly. So, public interest litigation is liberalizes public interest litigation liberalizes locus standi, means the other person can appear on behalf of the other person can approach the court on behalf of some other person who is not so strong or who is not so diligent. Question number 53. In which country was the concept of PIL originated? So, concept of PIL was originated in USA. USA. There were some important cases like NACCP versus BUTTON button, Sierra Club versus Morton. And in India, in late 1970s, under Justice P.N. Bhagwati, and V.R. Krishna Iyer. Iyer. The concept of PIL was imported in India. And in India, important case related to PIL is Hussainara Khatun versus State of Bihar. Hussainara Khatun case. Now, next question is, who was the Chief Justice of India when the concept of PIL was introduced to Indian judicial system? As discussed earlier, P.N. Bhagwati. Next question. According to section 44AA subclause 2(1) of Income Tax Act, a person carrying on business must maintain books of account if income from business or profession exceeds the if income from business or profession exceeds rupees 1,20,000 or turnover exceeds rupees 10 lakh, 10 lakh. So it is given under 44AA subclause 2(1) of Income Tax Act. Answer A is correct. 56. PIL in India is to be linked with judicial review, judicial activism, judicial intervention, or judicial sanctity. So, PIL in India is to be linked with judicial activism. Why? Because PIL is the most visible expression of judicial activism. वो कैसे है? Court proactively relaxes the locus standi. Court relaxes locus standi, devised noble remedies, and supervised state action. So, judiciary actively takes part in PIL and it is to be linked with judicial activism. Which type of allowances qualifies for deduction under section 16 subclause 2 of the Income Tax Act? It is straightforward question from Bear Act. So when we see section 16 subclause 2 of Income Tax Act, it um, allows for deduction in entertainment allowances granted to government employees, only to government employees. Private sector employees do not get the deduction. Mandamus may be issued by. So, very easy question. Mandamus may be issued by both A and B. Supreme Court also and High Court also. Supreme Court under Article 32 and High Court under Article 2 to 6. The provision for administration tribunals is added by. So, the provision for administration tribunal is added by 42nd Amendment. 42nd Amendment. 42nd Amendment. It introduced Part 14A, Part 14A, and Article 323A and 323B were added. Article 323A relates to administrative tribunal in service matters, and 323B relates to taxation, foreign exchange, labor disputes, etc. Question 60. The provision relating to free legal aid is given under. The provision relating to free legal aid is given under section 304 of CRPC, which is now 341 of BNSS, and it draws inspiration from Article 39A of the Constitution, Article 39A of the Constitution, which says, which is a DPSP actually, and which says equal justice and free legal aid to the poor. To poor. It also relates to Article 21. Article 21, legal aid is a part of free trial. Part of free trial. So answer is option B, section 304 of CRPC and 341 of BNSS. Question number 61. As per the Indian Contract Act 1872, an acceptance must be absolute and unqualified. What is the legal effect if an offeree's response to a proposal response to a proposal introduces a new term? If offeree's response to a proposal introduces a new term, it becomes a valid acceptance and new term is incorporated as a mere suggestion. No, it operates as a valid acceptance If the new term is not material alteration, no. It constitutes a counter proposal, thereby rejecting the original proposal, yes. It suspends the original proposal until the new term is accepted or rejected by the proposer, no. So answer is C. It is under section 7 of Indian Contract Act. Next question is 62. Designation of senior advocates is provided under. Designation senior advocates is provided under section 16 of Advocates Act. Section 16 of Advocates Act, answer is A, and B is, that is section 26 of Advocates Act, is about disposal of application for admission of advocates. Admission of advocates. Section 6 of Advocates Act is about functions of State Bar Council. State Bar Council. Section 15 of Advocates Act is about power of council to make rules. Make rules. So here answer is A. Question number 63. Right to pre-audience is provided by. Right to pre-audience is provided by section 23 of Advocates Act 1961. These are just direct questions from the Bare Act. So here answer would be B, section 23 of Advocates Act 1961, and section 33 is about advocates alone are entitled to practice. Entitled to practice. Section 16 of Advocates Act, senior and other advocates, which we have just discussed. Section 36 of Advocates Act is about disciplinary power of BCI. Disciplinary power of BCI, Bar Council of India. So here option B is correct. Next question is question number 64. Under section 24A of Income Tax Act, what percentage of annual value is allowed as standard deduction from house property income? This is also direct question from the Bare Act. So if we go through the Bare Act and under section 24A of Income Tax Act 1961, it is 30% of the annual value of income from house properties allowed as standard deduction. So here answer is option C, and this section 20 is omitted. 40 is amounts which are not deductible. And 50 is about special provision for compensation of capital gain. Capital gains in case of depreciable assets. Depreciable assets. Now, here option C is correct. 30% of the income from house property is allowed as standard deduction. Question number 65. The Bar Council of India has to lay down the standards of professional conduct and etiquettes for the advocates under. These questions are just direct from the Bare Act, so we need not discuss it much. So here the answer would be section 7(1) of the Advocate, section 7(1) subclause B of Advocates Act. Section 3 is about State Bar Council. Section 17 is about State Bar Council to maintain role of advocates. Role of advocates. Section 18 is about transfer of name from one state role to another. So option B is correct. Section 7 subclause 1 subclause B of Advocates Act. Minimum number of directors in a public company. Minimum number of directors in a public company is number of directors is provided under section 149 subclause 1 subclause A of Companies Act. And minimum number of directors in a public company is 3. In private company it is 2. In one person company it is 1. Maximum number of directors would be 15, and at least one female director. One female director and at least one director resident in India. So these criteria are described in section 149 subclause 1 subclause A of Companies Act. Here the answer is option A. 67. An associate company in relation to another company means a company in which that other company has a significant influence, but which is a subsidiary company of the company having such influence and includes a joint venture company. A company in which that other company has a significant influence, but which is not a subsidiary company of the company, having such influence and includes a joint venture company. A company in which that other company has a significant influence, but which is not a subsidiary company of the company having such influence and does not include a joint venture company. Here answer is B. A company in which that other company has a significant influence, but which is not a subsidiary company of the company having such influence and includes a joint venture company. It is given under section 2 subclause 6 of Companies Act. Now next question. Next question 68. The Indian Contract Act provides for specific situations where an agreement without consideration is not void. Which of the following agreement is valid despite the lack of fresh consideration? So, in section 25 subclause 1 of Indian Contract Act. Section 25 subclause 1 of Indian Contract Act lists exception. Exception for what? Exceptions to the rule. Which rule? We generally follow one rule: no consideration, no contract. But under section 25 subclause 1 of Indian Contract Act, we just find exception to this rule of no consideration, no contract. Here the contract is formed without consideration also, and it is about expressed in writing and registered under law for the time being in force for registration of documents, just like a promise made from husband to wife squarely fits. So here, a written and registered promise by a husband out of natural love and affection to transfer a property to his wife. This option falls under section 25 1 of ICA, Indian Contract Act, and here agreement is valid despite the lack of fresh consideration. Here it will be valid. Question number 69. According to Environmental Protection Act 1986, environmental pollutant means environmental pollutants are defined under section 2B of Environment Protection Act 1986. Any solid, liquid or gaseous substance present in such concentration as may be or tend to be helpful to environment. No, helpful, nahi. Only gaseous substance present in such concentration as may be or tend to be injurious to the environment. No. Any solid, liquid or gaseous substance present in such concentration as may be or tend to be injurious to the environment. Injurious to the environment. Solid, liquid or gaseous, तीनों covered है. Option number C is correct. Any solid, liquid in the as may be tend to, no. Option C is correct. Question 70. Section 66A of Information Technology Act was struck down under Article 19(1)A, read with Article 19(2) in case of Shreya Singhal versus Union of India. In this case, Supreme Court struck down Section 66A of IT Act, and it was not saved under Article 19 subclause 2. So, option number D is correct. Shreya Singhal versus Union of India. 71. Question number 71. Read the following statements related to Information Technology Act 2000 and choose the correct option. Statement number 1. Under the Information Technology Act 2000, a digital signature certificate may be suspended by certifying authority on the request of the subscriber or an authorized representative, or if it is considered necessary for public interest. And statement 2 is under the same act, a digital signature certificate can remain suspended indefinitely without providing the subscriber an opportunity of being heard. Without providing subscriber an opportunity of being heard. So this is incorrect. Only statement 1 is correct. 70. Here, section 37, subclause 2 of IT Act 2000 requires that subscriber be given an opportunity of being heard. Of being heard. So here only statement 1 is true. Question number 72. For the offence of murder committed by a group of 5 or more persons acting in concert on the ground of race, caste or community, sex, place of birth, language, personal belief or any other similar ground, each member of such group shall be punished within the provisions of. सबसे पहले मैं ये बता दूं कि this definition is of mob lynching. मॉब लिंचिंग के बारे में सब जानते होंगे. ये मॉब लिंचिंग का डेफिनेशन है एंड दिस फॉल्स अंडर सेक्शन 103 सब क्लॉज 2 ऑफ बीएनएस 2020. Section 103 subclause 2 of BNS covers mob lynching, Section 106 subclause 2 of 2000 of BNS, it deals with hit and run cases. 109 subclause 2 of BNS, it deals with attempt to murder. Attempt to murder. So here option B is correct. Question 73. An attempt to acquire sensitive information such as username, password, and credit card details by masquerading as trustworthy entity in an electronic communication is known as. It is known as phishing. Phishing means someone attempts to acquire sensitive information like username, password, credit card details, etc. just by um, um, just by impersonating someone who is trustworthy. So phishing is about impersonating someone trustworthy, and farming is hacker manipulates hacker manipulates website traffic, redirecting users to fake websites. Diddling is about to get money from someone on dishonestly. Phishing is about it is called SMS phishing. Users send fraudulent text messages and to track people, and and thereby they receive their sensitive information through that link. So here the answer is phishing. Option number C is correct. Which public interest litigation case resulted in Supreme Court of India laying down the principle of absolute liability? So here answer is MC Mehta versus Union of India, or AIR 1987 SC 1086. MC Mehta. This is also called oleum gas leak case. In this, the principle of absolute liability was laid down, which means with the enterprises which are carrying hazardous activities, they are absolutely liable for any harm arising out of their um, um, arising out of their negligence. So they cannot escape their liability. Here answer is option A. 75. Question number 75. Which section of Information Technology Amendment Act 2008 deals with the validity of contracts formed through electronic means? So, in this question, section 12, section 12 deals with validity of contracts formed through electronic means. Section 10A. Direct question from the Bare Act. Uh, Section 12 deals with acknowledgement of receipt of electronic records. Electronic records. Section 11 is about attribution of electronic records. Electronic records. And section 13 is about time and place of dispatch and receipt of electronic record. dispatch and receipt of electronic record. So section 10A deals with validity of contracts formed through electronic means. Industrial relations cover the following area: collective bargaining, labor legislation, industrial relation training, trade unions. Very simple question. Option D is correct. All of these are covered under industrial relations. Strike should be called only least percent of workers are in support of strike. So it is a recognized industrial practice. Industrial practice that at least 15% of the workers, sorry, 15% of the workers support the strike, then only strike should be called. Option B is correct. 78. Read the given statements and choose the correct option. Statement 1. Under the Contract Act 1961, a deduction equal to 30% of the annual value is allowed while computing income from house property. Statement 2 is where the property has been acquired or constructed with borrowed capital. The maximum deduction or interest payable on such capital is capped at rupees 2 lakh subject to conditions. This is covered under section 24 subclause A, and this is covered under section 24 subclause B. Both the statements are true. Option D is correct. Question 79. Which of the following sections of the Motor Vehicle Act 1988 defines the term owner? So here section 2 subclause 30 defines the term owner. Section 2 subclause 31 permit issued by state or regional transport authority. Section 2 subclause 25 is about motor cab, defines motor cab. What is motor cab? Which carries 6 passengers except the driver, not more than 6 passengers. Except driver. And section 2 subclause 32 defines prescribed. Describes the word prescribed. That is which is made under the rule, which is made under the act. Rules made under the act. Which of the following is a leading case on injuria sine damnum? Injuria sine damnum का मतलब होता है injury without damage. And this principle was followed in Ashby versus White. Ashby versus White, इसमें एक रिटर्निंग ऑफिसर ने प्लेंटिफ को वोट देने से रोक दिया था, ऑल्दो पार्टी जीत गई थी उसकी जिसको वो वोट करने वाला था, लेकिन इससे कुछ डैमेज हुआ नहीं, लेकिन फिर भी उसको इंजरी के लिए इंजरी के लिए उसको डैमेज दिया गया, क्योंकि यहाँ पे समटाइम्स इंजरी कैन बी कॉज्ड विदाउट डैमेज ऑल्सो। यहाँ कुछ नुकसान नहीं हुआ बट उसको इंजरी हुई क्योंकि उसका लीगल राइट वायलेट हुआ, उसने वोट देना था, उसने वोट दिया नहीं। तो यहाँ पे इंजूरियस इन डैमनम फॉलो हुआ एसबी वर्सेस वाइट में। राइलैंड वर्सेस फ्लेचर जो है ये इंपॉर्टेंट केस है, स्ट्रिक्ट लाइबिलिटी का प्रिंसिपल ले डाउन हुआ था इसमें। और डोनोग वर्सेस स्टीवेंसन नेग्लिजेंस पे है, नेग्लिजेंस एंड ड्यूटी ऑफ केयर, ड्यूटी ऑफ केयर। So here answer is option B. Which one of the following, which one is leading case on strict liability? Strict liability as discussed above, अभी हमने इसको डिस्कस किया है, Ryland versus Fletcher. 82. Which of the following cases principle of common employment was evolved for the first time? Risley versus Fowler. आंसर इज ऑप्शन नंबर बी, प्रिस्टली वर्सेस फाउलर। ये हमने अभी डिस्कस किया है, इसमें स्ट्रिक्ट लाइबिलिटी का प्रिंसिपल आया था। स्ट्रिक्ट लाइबिलिटी यहाँ एसबी वर्सेस वाइट में इंजूरिया साइन डैमनम, इंजूरिया साइन डैमनम। और वैगन वर्सेस माउंट में आया था रिमोटनेस, टेस्ट फॉर रिमोटनेस ऑफ डैमेज, रिमोटनेस ऑफ डैमेज इन नेग्लिजेंस इन नेग्लिजेंस। तो ये प्रिंसिपल ऑफ कॉमन एम्प्लॉयमेंट का क्या मतलब है? प्रिंसिपल ऑफ कॉमन एम्प्लॉयमेंट का मतलब है अ मास्टर इज नॉट लाइबल टू वन सर्वेंट फॉर द एक्ट्स ऑफ अनदर सर्वेंट। ठीक है, अगर कोई कॉमन एम्प्लॉयमेंट में बहुत सारे एम्प्लॉयज हैं तो जो इसमें मास्टर है, मास्टर किसी भी एक एम्प्लॉय के एक्ट के लिए दूसरे एम्प्लॉय को लाइबल नहीं है। ये प्रिंसिपल ऑफ कॉमन एम्प्लॉयमेंट ये कहता है। Question 83. Under Section 37 of Arbitration and Conciliation Act 1996, which of the following orders is not appealable? Not appealable. Refusing to refer parties to arbitration under Section 8, refusing to appoint arbitrator under Section 11, refusing to grant any measure under Section 9, refusing to grant an interim measure under Section 17. Here it is not appealable. So here answer would be option B, refusing to appoint arbitrator under Section 11. ये mandatory है, तो इसलिए ये option यहाँ पे correct होगा, refusing to appoint arbitrator under Section 11. 84. Latin word res ipsa laquitur. इसका मतलब है thing speaks its own story, its story itself. Thing speaks its story itself. Option A is correct. Simple question. In which of the following cases Supreme Court of India has pointed out that the rule of nemo judex in causa sua is subject to doctrine of necessity? Doctrine of necessity. तो इसका आंसर है जे मोहापात्रा एंड को वर्सेस स्टेट ऑफ उड़ीसा। इसका मतलब इस लैटिन वर्ड का मतलब है नेमो जुडिक्स इन काउसा सुआ। इसका मतलब होता है रूल अगेंस्ट बायस, रूल अगेंस्ट बायस, दैट इज द डिसीजन मेकर हैज टू बी has to remain impartial. और इस केस में जे मोहापात्रा एंड को वर्सेस स्टेट ऑफ उड़ीसा में ये कहा गया था कि रूल ऑफ नेमो जुडिक्स इन काउसा सुआ इज सब्जेक्ट टू डॉक्ट्रिन ऑफ नेसेसिटी। एज पर नेक्स्ट क्वेश्चन इज 86. As per the Constitution of India, after 86th constitutional amendment, which directive principle was modified to ensure early childhood care and education below the age of 6? This is direct question from Constitution. It is Article 45. Question number 87. As per Constitution of India, a linguistic minority in India, linguistic community in India seeks to preserve its unique script and literature. Which constitutional provision guarantees them the right to conserve the same? It is Article 29, subclause 1. Article 29, subclause 1. These are the direct questions from Constitution. Under which provision of Indian Constitution can a public interest litigation be filed directly in the Supreme Court? As discussed earlier, uh, as discussed earlier, public interest litigation can be filed directly in the Supreme Court under Article 32. Question number 89. X is accused of obstructing Y, a public servant, in discharge of his public functions when Y has following. Uh, a thief who was suspected to have taken refusing in a public hall. X was gateman of the said public hall. A charge shall state the law and section of law against which the offence is said to have been committed. Sahi? And shall be written in the language that is understood by the concerted party, specifically the accused, not necessarily. Shall set out the manner in which X obstructed in the discharge of his function. So here answer 1 and 3. Option number 1 and 3 is correct. Option C is correct here. Question 90. X is charged for knowingly selling goods marked with a counterfeit property mark and is brought before the magistrate. Which of the following is not mandatory to be followed under the Bharatiya Nagrik Suraksha Sanhita 2023? X is charged for knowingly selling goods marked with counterfeit property mark and is brought before the magistrate. Which of the following is not mandatory to be followed under Bharatiya Nagrik Suraksha Sanhita? So particulars of the offence of which X is accused shall be stated to him. True. X shall be asked whether he pleads guilty. True. 90 question. X shall be asked whether he has defense to be made. True. नॉट में हो जाएगा यहाँ पे अ फॉर्मल चार्ज शैल बी फ्रेम. ये जरूरी नहीं है कि एक फॉर्मल चार्ज फ्रेम होगा ही होगा, ये तीनों तो जरूर होगा. क्वेश्चन नंबर 91. Which of the following statement in the context of summary trial under the Bharatiya Nagrik Suraksha Sanhita is correct? If the accused does not plead guilty, magistrate shall record the substance of the evidence. True. The procedure for summary trial shall be the same as procedure of warrant cases under the BNSS. No, it would be same as not. It would be same as summon trial cases, not warrant cases, not like warrant cases. The procedure for summary trial shall be same as procedure for warrant cases under the BNSS. No, a magistrate of second class shall have the power to summarily try an offence if it is punishable with imprisonment for a term not exceeding 1 year with or without fine. No, the sentence that is passed in summary trial cannot exceed 6 months in the case of conviction. Correct. So it is option 1 which is correct. Now question 92. Which of the following statement in respect of directions of the Supreme Court in Arnish Kumar versus State of Bihar is not correct? Is not correct. Directions are to apply to cases under section 498A of IPC or Section 4 of Dowry Prohibition Act, and also to other cases where offence is punishable with imprisonment, which may extend to 7 years with or without fine. So this is correct. So this cannot be the answer. The magistrate, while authorizing detention of the accused, is to peruse the report furnished by the police officer, and only after recording satisfaction the magistrate must authorize detention. This is also correct. So it cannot be the answer. The decision not to arrest an accused must be forwarded to the magistrate within 2 weeks from the date of the institution of the case, with a copy to the magistrate for the reasons to be recorded in writing. This is also correct. So it cannot be the answer. Under Section 498A of IPC, a judicial magistrate may authorize detention without recording reasons. This is actually wrong. So this is the answer here. This option is incorrect. 93. Secondary evidence of a document means copies of the document. Secondary evidence is mentioned under 63 of Indian Evidence Act and Section 57 of BSA. 57 of BSA, which includes copies of the documents and oral accounts of the contents of the document. Both A and B are correct here. Next, 94. Evidence to document unmeaning in reference to existing facts is called, this is a factual question. Evidence to document unmeaning in reference to existing facts is called patent ambiguity. Original document is best evidence. Exception to this rule is contained in Indian Evidence Act. Indian Evidence Act. So it is given under Section 65 of Indian Evidence Act. According to Bharatiya Nyaya Sanhita, what is the maximum punishment for committing the offence of bribery under Section 173 of BNS? It is again a factual question. Its answer is imprisonment for up to 1 year or a fine or both. Question 97. Abetting the commission of suicide is given under Section 306 of IPC and 108 of BNS. Here options are incorrect. So 108 BNS covers abetting the commission of suicide. According to Bharatiya Nyaya Sanhita, what is the maximum fine for making or using a document that resembles a currency note or bank note under Section 182 subclause A? As discussed earlier, it is 300 rupees only. 99. A is at work with a hatchet. The head flies off and kills a man who is standing by. If there was no want of proper caution on the part of A, his act is excusable and not an offence. It is contained in clause. It is contained in Section 1. Excusable and not an offence. It is contained in Section 80 of IPC. Section 18 or 80 of IPC and Section 18 of BNS, which says nothing is an offence which is done by accident or misfortune. Misfortune. So his act is excusable under Section 18 of BNS or Section 18 of IPC. Last question. Section 152 of BNS, Bhartiya Nyaya Samhita, replaces which controversial law? We have already discussed it. It replaces 124A of IPC, which is sedition law. Option A is correct here. So that's all for today. Thank you so much.